Welcome to Middle Class Matters, Business News in English from Dr CMA Alagesan. Securities Exchange Board of India, SEBI, issued confirmatory order in respect of Subash Chandra, the chairman, and Punit Goenka, the MD, in the matter of ZEE Entertainment Enterprises Limited. Part number 19 continued. 100.5. Thus, prima facie, not only the LOC given by entity number 1 gave Yes Bank the comfort to lend against it, but also the comfort to appropriate the fixed deposit, and Yes Bank actually did so. 100.6. The factum of LOC was not disclosed to the company or its shareholders prior to publication in the annual report. 100.7. ZEE Limited has renewed the fixed deposit on June 12, 2019 with maturity on September 10, 2019. However, the said fixed deposit was liquidated and appropriated on July 24, 2019, that is within 1.5 months of renewal. Such untimely liquidation of a fixed deposit of INR 200 crore would have come to the attention of the management of ZEE Limited, especially entity number 2, who was in charge of the day-to-day functioning of ZEE Limited. Yet, as in any case, an intimation of liquidation would have been sent by Yes Bank to ZEE Limited. Thus, he was aware of the liquidation of the fixed deposit by Yes Bank in July 2019 itself. However, no immediate steps were taken by entity number 2 to address the issue. 100.8. At the time when the fixed deposit was created and when the fixed deposit was appropriated by Yes Bank in July 2019, entity number 1 was the non-executive director of ZEE Limited and the chairman of SL Group. Upon appropriation, he neither took any corrective steps nor brought the fact of his LOC or the appropriation to the notice of the Board of Directors of ZEE Limited. 100.9. On September 18, 2019, the 7 associate entities in identical language and through identical signatures wrote to ZEE Limited that it has come to their knowledge that proceeds in relation to a term deposit of ZEE Limited have been transferred to their current account and that they would be returning the said proceeds. 100.10. The bank statement for the period September 26, 2019 to October 10, 2019 of the 7 associate entities show that cumulatively they have transferred funds to the tune of INR 202.5 crore to ZEE Limited, that is INR 2.5 crore as claimed interest. 100.11. In order to show that the said associate entities have paid the amount equivalent to the sum which was appropriated by Yes Bank from the above said fixed deposit, funds were moved from ZEE Limited, its subsidiaries or other listed companies or subsidiaries of SL Group through several layers wherein a number of common conduit entities were used to mask the fund transfers, including companies which were connected to the entities number 1 and 2 and their family members to ensure that sufficient funds became available with the associate entities to pay ZEE Limited. Thus, circular fund transfers were done to show receipt of funds by ZEE Limited. 100.12. The fact that Yes Bank, after consulting with the leadership team of SL Group, as noted from Yes Bank's letter dated October 11, 2019, which has not been disputed by the entities, had to appropriate the fixed deposit towards the loans taken by the 7 associate entities is indicative of the fact that in the normal course these 7 associate entities had not been able to pay up the dues. Accordingly, Had the fixed deposit not been appropriated, these 7 associate entities owned and controlled by the promoter family of ZEE Limited would have defaulted. In the event of such a default, these 7 associate entities would have been exposed to legal action from S Bank in terms of the provisions of the Insolvency and Bankruptcy Code 2016. Securitization and reconstruction of financial assets and enforcement of Securities Interest Act 2002, recovery of debts and Bankruptcy Act 1993 and other applicable laws. Since the 7 associate entities were owned and controlled by the promoter family of ZEE Limited, any default on their part would also have exposed the promoter family's inability to pay debt of companies owned or controlled by them. The possible repercussions thereof would also have been the loss of trust of lenders in other SL Group companies. Clearly, the possible ramifications of the default by the 7 promoter owned or controlled companies would have been severe, and the same strengthens the prima facie findings that the entities had orchestrated the scheme to conceal the default by the associate entities and the loss that had been caused to ZEE Limited or other listed entities and subsidiaries of the SL Group. 100.13. The entities, to cover up the apparent loss to ZEE Limited, orchestrated the scheme involving layered transactions to show that the money had come back to ZEE Limited. 100.14. Consequently, the disclosure made by ZEE Limited in its annual report for the financial year 2019-20 was false. Further, ZEE Limited had also submitted false information to SEBI regarding receipt of INR 200 crore from its associate entities. 100.15. Despite the promoter holding of only 3.99% shares in ZEE Limited, the entities continue to be at the helm of affairs of ZEE Limited, and their actions have adversely affected the interest of 96.01% of shareholders. Their position in ZEE Limited or promoter group has been misused by them to devise the said scheme. 100.16. Entity number 1 was not only involved from the very beginning by virtue of issuing the LOC, but looking at the companies or body corporates involved in the scheme and the similar pattern of fund flow across 6 different chains, it is clear that entity number 1 was actively involved in the orchestration of the scheme, which has been found prima facie to be in violation of the securities laws. 100.117. As regards the role of entity number 2, during the period when the entire scheme was orchestrated, he was the MD and CEO of ZEE Limited. The remedial measures claimed to have been taken by entity number 2 were focused the procedural aspects of operation of a fixed deposit account and creation of fixed deposits. However, the genesis of the current issue was the LOC issued by entity number 1. That is, entity number 2's father, prima facie, no effective steps have been taken by entity number 2 to address this issue. Further, it was during his tenure in ZEE Limited as MD and CEO that the financials of ZEE Limited were misrepresented and false announcements were made to the stock exchanges. 100.18. ZEE Limited is involved in 2 of the impunged transactions which prima facie cannot be regarded as genuine transactions in light of the fact that SL Group companies or body corporates which were involved in layering the fund transactions, or these are under the influence or control of entity number 2 by virtue of his and his family members' shareholdings in them. This prima facie shows that entity number 2 was also involved in the orchestration of the scheme, which has been found prima facie to be in violation of the securities laws. Assessment of the directions. 101. Having considered the submissions made by the entities in respect of the observations or allegations made in the interim order, the issue that now needs examination is whether the interim measures taken against the entities need to be investigated, revisited in the light of the submissions made by them. 102. It has been submitted on behalf of the entities that the directions issued while the interim order are indefinite in terms of scope as well as time, as they restrain the entities from holding the position of a director or key managerial personnel of any listed company or its subsidiaries till further directions. To this submission, without prejudice to other findings in this order, I do find merit in the arguments advanced in this regard by the entities. As has been highlighted in various sections of this order, one of the key purposes behind the issuance of urgent interim directions against the entities was to ensure a fair and transparent investigation in the matter, which would not be possible while the entities are in positions of influence in ZEE Limited and the other listed companies. Subsidiaries identified as part of the scheme. The directions are temporary in nature and are aimed at safeguarding the interest of public shareholders of the company, balancing the set purpose of ensuring a fair and transparent investigation with the impact of the directors on the entities. I find it appropriate to modify the directions in the following manner. 1. The investigation in the matter by SEBI shall be completed in a time-bound manner and in any event within a period of 8 months from the date of this order. 2. Till further orders, entities shall not hold the position of a director or a key managerial personnel in ZEE Limited, other publicly listed companies and their own wholly owned subsidiaries under the control of the entities and have been identified as part of the scheme, nor in any resultant company that is formed pursuant to a merger or amalgamation of any of these companies with any other company, wholly or in part, or in any company which is formed pursuant to demerger of any of these companies. The rationale for same being that while the proceedings in the matter are in progress, it is SEBI's priority to insulate the assets of the public listed companies from exercise of any influence or control by the entities. The same rationale applies to wholly owned subsidiaries of such listed companies because their assets in effect belong to the shareholders of such listed companies. 103. While the entities may argue that even the limited restraint noted above will be excessive and disproportionate in the matter, it is emphasized that the imminent effect of permitting the entities to be in position of influence is that the ongoing investigation cannot be fair and complete. As has been highlighted earlier, the interest of entities are factually in direct conflict with the interest of the public shareholders and the company. As prima facie found, the entities have actively tried to conceal the very acts which have led to the loss of at least INR 143.9 crore to the public listed companies including ZEE Limited. 104. Entity number 2 has submitted that he is integral to the functioning of the merged company ZEE Limited's merger with Culver Max Entertainment Private Limited due to his experience in the industry and local expertise. It has also been stated that the scheme of merger also contemplates approval of the board for appointment or removal of the KMP of the company. In this regard, I note that the contact of entity number 2 as the managing director and chief executive officer of ZEE Limited has been found to be prima facie in violation of the provisions of PFUTP regulations and LODR regulations. His actions were in direct conflict with the interest of 96% public shareholders of ZEE Limited, necessitating imposition of temporary restraint on him. In this context, I find it apt to refer to a statement given by entity number 2 in an interview given to ET Now, which is as follows. However, Goenka emphasized that the merger is significant irrespective of his role, as the resulting entity will be under Sony's control. 105. Thus, in my view, as outlined earlier, the restrictions imposed on him are reasonable in the facts and circumstances of the case. 106. It is also learned that on August 10, 2023, Honorable National Company Law Tribunal has granted its approval to the above mentioned merger. It is noted from the replies submitted in this regard that post-merger entity number 2 would be appointed as managing director of the merged company. The same means that he would be entrusted with substantial powers of management of the affairs of the merged company. That very role in ZEE Limited is under question, and therefore, till the final outcome of the proceedings in the instant matter, it would be appropriate that he is not part of the management of ZEE Limited or any corporate avatar of it. Please like the video, subscribe to the channel. Please share to your friends who are investing in equity market to know how the equity market functions and your interests are being safeguarded by SEBI and how the others are doing it. Thanks for watching.